All right, if it's Friday, it's LNAW. Was cloudy, but it looks like it's clearing up, at least in the video screen. So it's clearing up behind me, which is good. And it has also been a court holiday. There's been no court today, which is also good because it gave me time to catch up on some stuff. And I also have a trial coming up Monday. It's also Juneteenth, which is a federal holiday, very important holiday. If you don't know much about it, I urge everybody to take a look at that holiday and study that. But so technically, it's 4 days of no court, but fortunately, I got a lot of stuff to do with this trial and work to catch up on. So it's not going to be much of a weekend for me, but happy Juneteenth weekend. Today, I wanted to discuss this Supreme Court case that just came down, known as Holland versus Brackeen. And it involves the Indian Child Welfare Act of 1978. When I'm talking about Indians here, I'm talking about Native American Indians. It was a set of laws enacted in 1978 to prevent the breakup of the Indian family. It creates various terms of art, which I think opened up this challenge. And I have mixed feelings about this, not because I don't agree that there should be different standards, but I have mixed feelings about this because of the whole dilemma between theory and practice. And then this can maybe then open up challenges to this law, as this Texas couple has done. So there's this Texas couple who is saying that it is unconstitutional that Native American families are given higher protections than other families. Okay, but once we get to the stage of termination of parental rights, where there are higher standards for Indian families beyond a reasonable doubt, which is the same standard in criminal cases for criminal defendants, versus clear and convincing evidence for everybody else, which is the standard in all other civil cases. Once we get to that point, justly or unjustly, oftentimes judges, courts are going to find, are going to terminate the rights of the child. If everything has been done properly, and that's a standard, but that's a big if, okay? And but there are different standards. I mean, then also these government agencies, these child protective agencies, I guess with Indian families, are supposed to provide active efforts as opposed to reasonable efforts with everybody else, okay? But even attorneys sometimes are kind of confused as to what are active efforts or what are reasonable efforts, and different kind of things. These are kind of terms of art. Does this really apply in practice? So this gives an opening now to this Texas couple to come in and challenge us. But really, this has to do with the history of Native American, the U.S. government versus Native Americans, and the breakup of Indian families, a trail of tears, forcing Native American children to assimilate to schools, these various schools, which I also find this argument be made by this in this case, Holland versus Brackeen, by this Texas couple, or whatever, is a kind of a simplistic argument, almost comparing it to similar kind of logic as opponents of affirmative action bring up. But it's a very different argument, and the irony is this trail of the Native Americans were being forced to assimilate to schools, and this affirmative action has to do with people trying to get in Harvard or USC or whatever the hell they want to get into. But it just has to do with and it's a completely different analysis because we're dealing with one specific issue, just as we would be dealing with segregation and slavery, and things that were sponsored by the U.S. government. We also have this whole breakup of the Indian families and Native American issues, and basically some would compare it maybe to the Holocaust or just different issues that the U.S. government has done that have basically decimated the Native American culture. And a lot of times you can just drive around here up in New Mexico, Highway 550 or different places, Chaco Canyon, Pueblo of Acoma, different places around the state of New Mexico, them wiped out. And a lot of times it's been the U.S. government coming in and doing this. And I thought it was a 7-2 decision, this Supreme Court opinion. It was 7-2. So you have people of different political philosophies and appointed by different presidents of different parties agreeing. All Democrats agreed to it, but I thought the best opinions were actually written by Amy Coney Barrett and Neil Gorsuch on this, and I think Mr. Gorsuch has experience in Indian affairs, and I thought it was a well thought out opinion. The dissenters, Clarence Thomas and Samuel Alito. Clarence Thomas went into how Now this will open up the door to commerce and business, and it was a money thing. It'll give the Native Americans greater protections when it comes to stuff like that with casinos and gaming or something of that sort. So that's not. And then the usual, our founding fathers didn't want the central government to have all this power. They wanted the states to have power, and this is taking power away from the states and all that usual jazz from those kind of people. But this is not. This is a lot bigger than that. This is a lot deeper than that, and it's addressing one thing. And we're never going to remedy segregation, slavery. The U.S. government's not, at least, or what happened with Native Americans. But at least it's creating, something. Now, the reason I have mixed feelings about it again is whether in practice, if this is not being done, then it's creating an opening. If this is just theory for professors or people lecturing on LNAW or whatever to talk about, then or to make an extra, some bureaucrat can make some extra money, or just have so a professor can write more books about this kind of stuff. If that's all this is about, then it just creates an opening for people like this to say, even though really in practice there may not be any difference, but it can create an opening saying that it's not fair that they have higher protections. But this is very different from affirmative action, which is a more generalized thing where it's kind of basically created by these institutions, whether it's universities or different things. And I'm not gonna, and I've talked about affirmative action now recently, and because a few of the issues I've been talking about have been kind of tied in, but I really don't like that phrase. I actually hate that phrase, affirmative action, and I don't want to. I'm not going to talk. I'm never going to say never, but I'm not going to talk about it really from here on out, because I feel like it's pitting it's creating a ruse from the real culprits. Okay, and these are systems, corrupt or not, whatever, that have started from ancient Rome to London to New York or whatever. Now they've trickled down all over the place, and now everybody sweats it and think that's the way they're going to achieve their dream, by going to these big universities. And as I've talked about before, these like with that online thing and all that stuff, these universities are. I think this is just another ruse, and it's really the universities that need to start looking and see what direction they're going to go in. And the more importance we give to this whole thing with affirmative action, or debating it, it's dividing people, it's creating more tension, and it's creating importance to a system that's being watered down because of these different ideas and different things that they're trying to do, maybe to fix the wrongs of the past, but it's really just causing more problems. So I think the best thing for me to do, at least in regards to affirmative action, is not talk about it anymore. And I'm not going to use that phrase anymore, okay? So, and I'm not going to talk about it. It's not. I want to talk specifically about issues, but I think ICWA is a very different thing. And I will talk about it. I'll compare it to the logic people are using, but I'm not going to talk about affirmative action as an issue and go into that. But I will say that in regards to comparing it to ICWA, it's a very simplistic argument, and it's not. ICWA is dealing with a specific issue in regards to the U.S. government and how they directed certain policies towards Native Americans that basically wiped out their culture. And Mr. Neil Gorsuch brought that up. Justice Gorsuch brought that up, and it's important to maintain that tradition, those cultures, and that's what ICWA was really trying to do. And it's giving tribes, the tribal entities, tribal governments, concurrent jurisdiction, which means basically they have control, they have the power to maintain the Native American heritage that would otherwise be lost if these government agencies come in, take the kids out, and put them with some other non-Native family who has some 8,000 square foot house in Rio Rancho with a PlayStation or whatever, but then now they've completely lost sight of their Native American heritage. And that's, if we keep going down that road, that's gonna, and I really shouldn't say that that's an important aspect of American. We are sitting on lands that were Native, were controlled and had Native American cultures and different things, and then now we have a government, the U.S. government's come in and has been slowly trying to wipe that out. So not only would it do good for the U.S. government, who likes to espouse diversity and all of that in maintaining cultures, but it also is important, really, as a form of remedy, to at least somewhat maintain a culture that was unjustly wiped out. Okay, so that's all I have to say on that issue today. And have a great Juneteenth weekend, everybody. Okay, thank you.